Good morning, everyone, and thank you, Joe, for that warm welcome. I'm delighted to be the new member of the Fox Williams team, and I hope to work alongside some of you in the future. So today I'm going to speak to you about monitoring the remote workforce. Jess, could you pop the next slide on, please? So there are many positives to home working, but one of the consequences for employers can be a concern about standards slipping the longer it goes on. And employee monitoring is one of the solutions for addressing those concerns. However, a recent YouGov and SkillsCast survey found that 59% of the 2,000 employees surveyed wouldn't work for an employer that tried to use remote monitoring software to track their work at home. Quite an interesting statistic. But what do I mean when I talk about monitoring? Well, the options are varied and include content monitoring, so emails or other electronic comms, specific checks on individuals or group activity, and spot checks as well, so relating to the activity itself, such as website traffic or email volumes, rather than in relation to particular individual employees. You might be thinking, well, monitoring's nothing new. It's been an issue for some time now, but pre-COVID, the emphasis with employee surveillance tended to be towards ensuring internal compliance. And since the start of the pandemic, it's clear that there's been an enhanced focus on productivity and performance monitoring instead. And we foresee this continuing as working from home arrangements settle into agreed long-term patterns. Concerns about efficiency and loss of supervisory control are quite common in relation to home workers. And obviously from a performance perspective, managers can't review their remote team unless they've got supporting performance evidence available to them. As a result, sophisticated methods of digital monitoring are becoming more common, and these often equate to stamping the digital time card. So for example, recording when an employee logs on, opens their work-related apps, engages with Teams or other video conferencing. And all of these can reveal a pattern of working hours. They can identify if an employee is doing what's expected of them, or from a welfare perspective, it can allow you to think about if any untoward or excessively long hours are being worked. There's also facial recognition software that can monitor time spent at the laptop, and PwC employees are no stranger to this because last year the organisation introduced it to log screen absence for home workers. And they faced quite a lot of criticism in the press, but argued at the time that it helped them meet their compliance obligations as workers would normally be monitored on the trading floor. And indeed, the FCA has declared that it expects rigorous oversight of financial industry employees who are working from home. There's also the ability to take desktop screenshots, record computer mouse movements or keystrokes, which would reveal the full content of communications in real time. I think 97% of you that answered our poll at the beginning suggested that you're not already using this type of software, but it may be something obviously that is in the pipeline or something that you're interested in finding out more about. Well, it can be downloaded remotely onto home worker laptops, or alternatively, it can be installed in advance on equipment for new joiners. And health and safety obligations are another consideration. So while we remain under the work from home guidance for another couple of weeks, 19th of July, and possibly beyond that date, really, you're likely to keep quite a close eye on when employees are accessing the office and on which days, so that you can control both the numbers and make sure that you're complying with the health and safety duty that you owe to staff and visitors. And to keep the office COVID secure in this way, some employers might enhance their monitoring in relation to security passes or facial recognition software. There can be cameras in common areas, or in some cases, equipment tracking software. But we do, as ever, recommend caution and bespoke advice if you're thinking about these enhanced monitoring methods, because the legal issues are often far from straightforward. Could I have the next slide, please, Jess? Which leads me to the legal background and the importance of ensuring that your monitoring will be legally compliant. So what does the law say and how has it changed? Well, literally nothing's changed in light of the pandemic itself, and the law does remain as it has been for some time. A summary of the various legal considerations is set out for you on the slide, but the starting point is unsurprisingly UK GDPR and the DPA 2018. These are engaged whenever you're processing employee personal data, and you must have a legal basis on which to do so. Unfortunately, employee consent is not going to pass this test because it's not considered to be freely given in the employment relationship due to the imbalance of power. So the legal basis which is most likely to be relevant to your monitoring is that of the legitimate interests of the employer. That means you should ideally carry out a legitimate interests assessment, which will allow you to assess and document the process you followed to identify your legitimate interests and the justification behind that. Examples could be preventing the misuse of company systems, protecting data, ensuring compliance with internal policies and regulatory requirements, or even to monitor generally the performance at work. A data protection impact assessment should also be undertaken, as most employee monitoring activities are recognised as posing quite a high risk to employees' rights and freedoms. And both of these steps will help you assess what you're trying to achieve or guard against, and whether the methods that you've chosen will amount to a proportionate means of achieving those aims. The Employment Practices Code from the ICO also offers helpful guidance for employers. As things stand, it's currently being reviewed, which is pretty urgent because it hasn't even been updated to reflect the DPA 2018, and nor does it particularly reflect the massive tech advances that have happened in the last 10 years. There's also supplementary guidance, and that covers both systematic and occasional monitoring. The ICO accept that some employee monitoring is par for the course in the employment relationship, but the overarching message is that on almost every case, a data protection impact assessment will be required. The Investigatory Powers Act 2016 is also relevant, and as are the subsequent monitoring and record-keeping 2018 regulations. However, the important point to note in that regard is that these apply in relation to interception, so monitoring emails as they're being sent out in real time, rather than the standard employer practice of monitoring sent emails that are within your own IT systems. The European Convention on Human Rights, Article 8, right to privacy and family life is also of relevance, although there is no standalone legal right to privacy in the UK workplace. That said, the Article 8 right often does feature as an employee argument, because UK courts and tribunals are required to interpret UK law in line with the ECHR. And the argument frequently crops up where an employer has monitored private emails or messages sent on work systems, or looked at personal social media accounts or devices, and the findings have then led to disciplinary action or a dismissal decision. And what the case law tends to demonstrate is that there's a very clear balancing exercise to be conducted, and that's between the individual employee's expectations of privacy, which will generally be lower in a work context, alongside the competing legitimate interests that the employer is seeking to protect. Proportionality is often the linchpin, and while much of the case law does fall in favour of the employer in that regard, it will be interesting to see if it changes as home working cases start to trickle through. Again, at a European level, there's guidance from Article 29 Working Party Opinion from 2017, but it's no longer directly applicable to the UK since Brexit. It just remains a source of useful guidance on GDPR and monitoring. Next slide, please, Jess. So focusing now on the legal risks to the business, well, if the monitoring you carry out is viewed as too excessive or intrusive, then employees may raise a grievance or resign, arguing that the employment relationship has been irreparably damaged. You could therefore face a constructive unfair dismissal claim under the Employment Rights Act as a result. And equally, any decision on your part to dismiss an employee must obviously be for a fair reason and follow a fair process. And that means that monitoring evidence on which you rely to reach a dismissal decision should have been obtained in a legally compliant way. A complaint to a manager or HR that the company's monitoring activities are unjustified and in breach of the UK data protection regime could arguably also amount to a whistleblowing disclosure. There are various hurdles for an employee to get over in that regard, but it can be quite an attractive unfair dismissal claim for those who don't have 2 years service and because of the potential for uncapped damages. A detriment claim is also available more widely to workers if they can show that they've been treated unfavourably for making a protected disclosure. Also, do take care in relation to the groups of employees you choose to monitor. Ideally, don't focus solely on home workers, for example. You might have a higher proportion of employees with protected characteristics who are working from home in the long term. So there could be exposure to discrimination claims as well under the Equality Act 2010. In terms of enforcement, individuals can bring a claim for breach of the GDPR, and don't forget also the management stress that can be inflicted by a data subject access request if they want to gain access to all the personal data that the business holds against them. But the ICO also has the power to investigate complaints and where appropriate can take enforcement action. That carries the risk of reputational damage, but also the chance of a fine of up to 4% of global turnover or £20 million, whichever is greater. I mean, obviously these figures are most likely to be relevant to mass data breaches, but I do think it's still one to be aware of. Could we have the next slide, please? In terms of practical tips for compliant monitoring, broadly, do ensure you're monitoring in a way that's compatible with the law. The workforce needs to have a clear understanding of when their personal data is likely to be obtained, why you're obtaining it, how you'll use it, and to whom it may be disclosed. And so transparency is incredibly important in this regard. The best way to go about that is to keep your employee privacy notices up to date to reflect the monitoring that you carry out. Because communication is going to be fundamental, it means that employees are fully aware of the curbs on their privacy expectations while they're working from home or in the office. And that can itself go a long way to preventing complaints further down the line. I've already mentioned the importance of legitimate interest assessments and data protection impact assessments, not least because they provide a defensive paper trail in the event that you face any complaints, tribunal claims, or ICO inquiries. If you do introduce new methods of monitoring, please make sure that your existing policies are updated to reflect the implications. Employees who've been with you for some time might view more intrusive monitoring as a negative shift and that demonstrates a lack of trust. Therefore, any new policy needs to fully explain your intentions so that no one is really caught by surprise. And all the steps that I've mentioned so far will help you demonstrate that your employee data processing is fair, transparent, and for justifiable reasons as required by the legislation. But proportionality will also be key. Is there a less intrusive way to achieve the same aim? And if so, why is it not appropriate in these circumstances? Would it be sufficient, for example, to monitor email traffic rather than to access individual messages? And is the use of facial recognition software really necessary? For some highly regulated industries like financial services, then the answer might be yes, but you do really need to show why you've reached that conclusion. And similarly, it's quite important to avoid mission creep. So the data you obtain should only be used for the purposes you've specified and explained in advance, or you could risk falling foul of the law. The next slide, please. Managers also need to be trained on your new policies, taking account of their roles in relation to the processing of data and the implications for getting it wrong. For example, if someone's reviewing performance data to carry out an annual review, then they should be aware not to use that information for any other purpose. And as with all employee personal data that you collect, do ensure that it's stored securely. So the usual methods will help: encryption, password protection, and generally not leaving it on a train. A limited number of people should also have access to the data. So perhaps a few members of HR or appropriate people in the senior management team. It needs to also be retained for no longer than is necessary to the extent that it's still relevant for the purpose for which you collected it. Do bear in mind, it's also not just a case of crossing the T's and dotting the I's when it comes to monitoring. It can have a huge impact on the relationship of trust. So don't underestimate the damage to morale that can be caused by what some employees might view as an unnecessary intrusion into their private lives, particularly if the plan is that they'll be working from home on a long-term basis. And speaking of unnecessary intrusion, well, covert surveillance is rarely going to be appropriate. It's only going to be in exceptional circumstances where it's endorsed by senior management, for example, if there's criminal conduct suspected, and it's not even acceptable in the Houses of Parliament, as we've seen over the last fortnight. I think the investigation into the hidden CCTV camera in Matt Hancock's office is ongoing. But it's also a useful reminder. So covert monitoring does come with controversy and tricky legal issues, and perhaps you don't actually want to know what it might reveal. Finally, don't forget that there is still value in the human approach. So regular manager check-ins with home workers using Teams and other video software, perhaps manual time recording rather than wholly automated processes, because the old methods are not necessarily redundant. And if they work well for your organization and they help you to maintain good working relationships, then you may not actually need to take your employee monitoring to the next level after all. So I hope you found that helpful. It was quite a brief run through, but hopefully gave you some useful pointers.